Thank you for welcoming us down here. We're from UC Berkeley. We come down to Central Valley every first Friday, every third Friday to give legal workshops and also free office hours, because we know that at early stages in your business, it's very difficult to afford an attorney. Well, it's difficult to afford an attorney anytime, but in particular at the beginning of a business's life. And that's when you really need a bunch of attorneys around because of things like the ADA or other things that we do workshops on. We do things on hiring, we do things on forming your entity, regulation, other things like that. So we're going to be working with the SBA to do more workshops here. Watch for their literature about when we will be back, but we usually are here every third Friday and in Merced and Modesto every first Friday. And we also have regular office hours. Now, at the end, there'll be a contact slide with some information about that. But just know, so you know, you can sign up if you can't afford an attorney. You can sign up for a 40-minute free consultation with a lawyer any Monday or Wednesday between 1 and 5 p.m. Okay? And the link at the end, which we'll, I'll put up on the board here too, but it's at the end. You just sign up through our website there. And as I said, any Monday or Wednesday, there's usually space that you can talk to an attorney. Okay, and today's session, we're going to be focusing on the ADA. Particularly, we're going to be focusing on businesses' compliance with ADA, not only in the sort of physical realm, the sort of barrier realm, but also some other realms that the ADA does apply. We'll primarily be focusing on the building aspects of things, and this is true whether you're a renter or whether you own the building. ADA compliance is very, very important. It's like the roof on your house. You just can't sort of let that thing go. So we're going to give you some tips on how to deal with that. Introducing Desiree, who is our deputy attorney and has studied these issues a lot. And then I'm going to come in at the end with a little bit more on leasing and the ADA. Okay. All right, please.
After the leasing part, we're going to have William from the SBA lead the discussion on ADA itself from the perspective of someone who has a disability and how you might be better able to address this. So hold your questions to the end. We'll try to be as fast as possible with this one. We're aiming to be 15 to 30 minutes. So let's start. So beginning before, and the mission of the ADA, or the American Disabilities Act, is for equality and independence for people who have disabilities, so that they can just live life normally and have access to things that they would have if they didn't have the disability, right? So the regulations are there to benefit them, but they benefit businesses as well. As we can talk about later, businesses who address issues of ADA will have a bigger customer base, and families of people who have disabilities are more likely to also frequent those businesses and support those businesses, because they know that it does take money and time to remedy ADA issues that you might have and getting up to par with compliance. So you want to keep your customers happy, and let's talk about what is a disability. Now, according to the ADA, it's any physical or mental impairment that substantially limits one or more functions of a person's day-to-day life, but it also covers people who are regarded as having such an impairment, and this part of the ADA is something that gets confused a lot. So let's say I am applying for a position and I have a deformity where I don't have visible ears, like you don't see any ears on me, and you think that maybe I have a hearing disability or impairment, and you think that because of that you don't want to hire me. Maybe you think the look of not having the ears will be unpleasant to customers, or you think that it will hinder me in my abilities to do the work, but you don't ask me, I haven't said anything about it or whatever. Even though I could have eardrums that are fully intact and I don't have a disability, I'm being perceived as someone who has a disability, and so I fall under the ADA, and so I can sue you, and you can have issues for that just because you treated me as someone who had an impairment, and so I get the benefits of that. So who must comply with the ADA? Everyone, and hopefully everyone can come into compliance with it. It's really more geared towards enforceability with people who have 15 or more employees. But even if you have 2 employees and you open up your place as a public place of business, and you have people coming in, you have to comply with the ADA. The levels of compliance will change, and we'll talk about that throughout the presentation. Generally, it's 12 categories, but the bottom line is that all businesses are gonna end up having to comply, even if you're just an online business, and we'll talk about that as well. So penalties for non-compliance do exist, and here we talk about, the maximum penalties have gone up. In California, there's also other things aside from the ADA, which can be added on to ADA claims to make penalties higher against businesses. And private lawsuits are generally about $15,000, which is usually more than what's necessary to get into compliance. So getting yourself up to par and checking how much it will cost could be a better benefit today. So categories of ADA compliance will range from general non-discrimination measures, and that's for the people coming in as well as employees. So it's not just your customer base. And reasonable accommodations will be made for customers as well as employees. So if I'm already working for you or I'm going to be working for you and there's one thing that can be changed easily for my position, you should be doing that. Now, if I am applying to be a secretary and I tell you that I cannot type and I cannot talk on the phone, there's a whole bunch of things, but those are the necessary aspects of that position, then you can discriminate in the sense of, I'm just not a fit for that position because I don't have the qualifications for that. But let's say it was a hearing thing and there's an easy accessible telephone change that we can do, you have to be open to those types of changes. So it's not that you have to do everything possible, but you have to be reasonable with your accommodations. Building accessibility is the biggest issue where we can physically see whether or not you're complying with the ADA. That's where most people are going to be in trouble with the ADA when it comes to construction issues. And this could be as the initial stages of entering your business, like a ramp, the street in front of your business, or the actual parking lot and the lines that are drawn out there, which we'll also talk about. And website accessibility. Now, if anyone here can tell me which one of these is a service animal, you get a prize. There's no prize.
Oh.
Go ahead. Tell me. The prize is my thing. Which one do you think? Is it
B?
B? Is this the German Shepherd?
Yeah.
Any of these can be a service animal. So that's the tricky part. I'm so happy you didn't win. Right? So a lab, even a Yorkie, any type of animal that can do the service needed for someone, which can be tricky. And so a lot of people nowadays try to pass off little lap dogs as a service animal. And they're smart little Yorkshire Terriers, and I have one that comes to my presentation sometimes, so you should come just so that you can meet him, right? But anyway, the two questions that a business might or can legally ask someone is, one, is the animal required because of a disability? And two, what work or task has the animal been trained to perform? The animal being trained to perform something is how you know that it's a service animal. Now, some places will think that, oh yeah, well, I want to see that training, the proof in writing, So they'll ask for the proof. Show me the paperwork for your animal. There's no paperwork. There's no paperwork required, and it's not required that the animal is trained at some facility like the Ivy League schools of dog training or any. There's just no one place that an animal has to go through to do the training. If I have a disability, let's say that stops me from being able to pick something up from the ground, I can get any dog and train that dog myself how to pick something up from the ground, and now that dog is trained. If that's something that answers the impairment that I have on a day-to-day. So you can't tell. So even the little lap dogs, a lot of people are like, well, what kind of training can that dog have? There's a lot of little dogs that are now being trained for people who are diabetic, and the dogs are able to sense something in the breath to know the level of sugars and let the person know if they're going to be having a fainting spell or if their sugar is too high or too low, so they know to address it. So those little lap dogs are perfect for that because they can smell the breath while they're being held versus walking around with that German Shepherd on your arm.
I have a question. Can you put a sign that no dogs are allowed in your business and still be faced with a lawsuit?
Yeah, because no pets are allowed, but a service animal has to be allowed because you have to allow someone access as they would if they didn't have the disability. So when it comes to restaurants and food places like that, they get confused with the the FDA, Food Drug Administration laws, and they'll say, well, pets aren't allowed here because of the hair and stuff like that. And it's like, oh, even hair salons. But no, if it's a service animal, it's allowed. That's it's not a pet. So as we see here, there's a therapy animal category, an emotional support animal, and service animal. and they each get different protection. The more on that side, the more protection you get. So service animal gets granted access everywhere because he or she is what the person needs to be able to have their day-to-day. An emotional support animal, that could be someone who has post-traumatic stress disorder or some type of anxiety disorder, and the dog is their emotional support, literally, to help them in their day-to-day. That type of animal can get protection when they're flying. That animal doesn't have to get an extra seat, in the plane. They don't have to pay the pet fee because it's needed for that person. There's paperwork for that one. The person has to have a mental impairment usually that's shown on a paperwork, So when you're flying with a service animal, again, you don't need any paperwork. If you're flying with that ESA, you're gonna have the paperwork for the dog and for the person attached to the dog. And for a therapy animal, this animal doesn't get access to many things except hospitals and stuff like that. The training is just to show that the dog is able to perform certain duties without being distracted, and there's a little training for that too, and a test that they have to pass in order to go and volunteer in nursing homes and hospitals and stuff like that. But that type of animal doesn't get protection with the person because it's not that the person needs it. It's just that that's a working animal in a different sense. What else? So again, businesses cannot require any proof or medical documentation because there is none necessary or available for the service animal. And you will find a lot of people who fly with service animals and have little vests on them and stuff, and it'll be like a nice pit bull that's able to fly and everything and has a little service dog vest. There's no vest necessary either. Just like there's no paperwork, you can buy those anywhere online, and it doesn't mean that your dog is trained or anything. So don't be tricked by those also when you're walking by someone. You're like, oh look, he has a pit bull, but it's okay. That might be a dangerous pit bull. Also, so for housing also, let's say you're a landlord and that's your business, somebody comes in and they're signing and you say no pets are allowed in the building, that's fine. Again, you could even have a sign, you can have it in your application and everything. But they come in with that ESA, it's all of a sudden not a pet anymore. It's just a necessary thing for them. And that middle section does have protection for housing also. Moving forward, earlier when I was saying about telecommunications services, there's a line for that, and it's easy to maneuver. If you're getting a lot of calls, like customers are calling to like order stuff or whatever, and they call into one of these answering services and you start hanging up on them, you just won't deal with a middleman or woman, that's just the term, right? The middle person doing the relay call, you can get in trouble with the ADA for that, It's not something that you have to like train people to do, but don't hang up on people who are calling through a service. Now for online content, it's becoming easier nowadays to just market yourself online and throw things out there. And a lot of people think that, hey, that's not a physical place, so I don't have to worry about it. But no, you have to worry more about it because now people, predators who are looking to file lawsuits can find you on there. So the Department of Justice considers all web access points, right? So this can be if you have social media accounts, you have your own standing website, all of those have to be as compliant as possible. If you have Instagram or Facebook, you're seeing that nowadays they have like this new thing where you can add all words onto your images to describe the images. So that's helping it become more ADA compliant. So you don't just toss the image on there. You can write little title words and everything on your website as well. And this will actually help you with search engine optimization because your natural phrasing that you're adding on there to let people know what's on the image, the crawlers on websites are reading that too. So it'll help you on the ranking when people are searching for you as well. So it's actually helpful for you to follow along with this. There's no like one list of things that you can go check off and say, hey, I'm following it through the ADA. But right now there's like these standards, WCAG 2.0, AA, as I don't know how to pronounce that any other way, WCAG or something. It's quite long, but you can look it up online and it'll tell you it's just what's perceivable, operable, understandable, and as robust as possible. So again, as long as you're explaining your images, you want to make sure that any of the coloring that you're using is not hard to see. If someone has problems seeing red and green, and you're using red and green wording with the background, and they won't be able to see any words on there. That could be an ADA claim as well. So you want to have as much contrast as possible. And now here are some important cases. There was this National Federation of the Blind versus Target in 2006, and they found there that a website is a public place of accommodation. So earlier when we were talking about the 12 categories or so that qualifies as a public place of accommodation where you open your business up to people, the website is a public place of accommodation. This was with Target. Target has public, actual physical locations where people are looking in or whatever, so their website needed to be in compliance as well. So it was a little open out there, like, hey, what if I only have a web-based business? You know, can I not have it be ADA compliant? And later on in 2012, the National Association of the Deaf versus Netflix came about and let us know that no, you're not clear just because you have a website-only business. As you know, Netflix doesn't have any physical locations, and this case found that even Netflix had to comply with the ADA. Just because they had an online business or whatever didn't mean anything. There were still ways. Just like I said, the contrast and coloring, the alt tags, any description that you can put on there is going to be better for you and the person visiting your website. Steps towards digital accessibility. Again, we talked about like that level that you can check for as much as you can find out there. Like there's no checklist right now. You just want to make it as ADA compliant as possible. You know, that might be an area to go into and open up a business in, you know, helping people be ADA compliant with their websites. You know, it's a niche field and it's something that's necessary and it's not being fully addressed right now. So use the alt tags, text, keyboard accessibility when you're checking out. Like if you have a business where people are buying products on your website, they shouldn't have to check something in order to check out, because if they're just using, if they can't literally check and they're just using like a tab on their keyboard, it should be able to go and do that little check on there. It seems like something so simple and minor in the checkout process, but that's an ADA thing that you can easily address, and it doesn't cost much to address, you know, so you should be addressing it. Use audio and visual components. If you have a YouTube account and you just do a visual video, you upload it, after a while, it'll show on the side, like you can download the text version of it, because YouTube is a big business. They're trying to be ADA compliant, and they're helping you be ADA compliant by having the whole text written out for you. So you don't even have to go and pay for someone to do this for you so that you can have the text. You could just grab it off of YouTube. So in the text, I keep saying text instead of transcript, that's what you're looking for. Use scalable, resizable text on your websites. You know, sometimes they're too small, and sometimes websites just stop you from doing it. It's, again, something simple for the ADA. Reasonable accommodation, again. When I say simple, I mean reasonable as well. Let's see. According to the Equal Employment Opportunity Commission, a reasonable accommodation is any change in the workplace or the way things are customarily done that provides an equal employment opportunity to an individual with a disability. So it can cover most things that enable an individual to apply for a job, perform a job, or have equal access to the workplace. So when you have people applying for jobs on your website, that's why you want to have that little line in the bottom letting them know that if they need any accommodations to apply to the position, they can contact you and give them a way to call you, email you, or something. It does not cover removal of essential job functions, as we were talking about earlier. If I'm applying for a secretary role and I can't do the basic tasks that a secretary provides, you would have to get a second secretary to do that. So you don't have to hire me because of, you know, that accommodation that you're trying to meet. There's specific requirements for making built environments accessible, but only reasonable actions are required. And also with requirements, let's say building requirements, the specs, like making a new building that's to code doesn't mean that it's to the ADA standards. Building codes change from city to city, and the ADA standards are federal, so you want to follow the federal. You want to follow their guidelines, because you can spend a lot of money starting a new project and everything, and it's too code for that building, and it's not ADA compliant. Usually, for example, when you buy cabinets for a sink, the usual measurement is like, let's say 36 inches or so, or 34 inches, but it needs to be 36 inches of clearance in order for it to be ADA standards. So buying the regular one is not going to cut it. You usually have to get it specially made, and it seems crazy, but it's a reasonable accommodation too. You should easily look into this. Undue burdens shouldn't happen. If you're trying to make these reasonable accommodations and yet they're eating at your bottom line so much that you're just going to be negative and you're just not making any money in the business, then you might have found yourself an undue burden, which you don't have to drive yourself into debt in order to be ADA compliant, and so you can escape it because of this. Now, like I said earlier, if you get sued, the lawsuit is usually more than it is then, to just get yourself up to ADA compliance. So you want to check it out beforehand and not try to just use this as a scapegoat. A business's overall resources determine what constitutes an undue burden, and it's hard. I can't just give you a formula right now for you to test, and it's something that you end up having to go to court and say, oh no, look, it's an undue burden on me because of this and that. And you have to pay that attorney to go to court, and the time and money is going to end up being more of a drain on your business. And if they lose, you still have to go up to compliance. So one of the things, is the space already complying with 1991 ADA standards? I asked that question because if you're compliant up to that point, there's no grandfathering of laws, when it comes to ADA. But if you're compliant up to the 1991 standards and no updates or changes or alterations have been done to the space, it can be that you don't technically have to comply to the latest 2010 standards up to this point. But again, the law is a living and breathing thing, so that animal could change tomorrow and you'll be in danger. So you want to be in compliance as much as possible. But if you change one thing after this grandfathering, which is not really grandfathering, you have to bring everything up to compliance for the 2010 standards. So changing existing structures is covered in there. So that's physical changes of like door, frame, everything. But it even counts when you're restriping a parking lot. That can seem like something so simple, like the sun has, faded it out, but you make that change, you have to make changes to everything. So this is just saying, again, if a business chooses to alter elements that work in compliance with the 91 standards, the safe harbor no longer applies to those elements. So that safe harbor is the better term, because there's no grandfathering, but there's a safe harbor clause. So requirement of removing architectural barriers when readily achievable. Again, as you see over there, the Bamboo Shack has a big step, and that step could be to code, and yet it's not complying with the ADA standards. So you want to put in that ramp, and with the ramp and everything like that is going to be something you want to look into. And so when you're doing these things, it's hard to figure it out. You want to talk to an architect to see, but this person needs to know about the ADA standards too. So not everyone who just does building code stuff knows the ADA. And they can tell you that you're ADA compliant, and you very well might not be. So you don't want to just go with them. You want to look up the standards as well. The federal government has a lot of material for small businesses to learn the specific compliance levels. So always making accessible entrances or making a sign right here. You see, it was impossible for them to do it with this staircase. So they have that little push for assistance button on the side. Or have something where people know from your website or other social media accounts that they can call you and you can meet them and have like a little curbside assistance. Again, examples of parking, if you're just half an inch off of the standards, you can get in trouble just for that. And one of the things with parking, people go around doing lawsuits like for ADA claims, and an attorney can file a complaint against you and let you know, like, hey, somebody I know, the plaintiff, he went to your establishment, saw that the parking lines were blurred, so he couldn't really tell whether or not it was like compliant or that it was there where he could park, so just fix the paint job, email me pictures and let me know when you fix this so that I could let my client know and we don't have to file a lawsuit. Now, you think, oh my gosh, I want to be in compliance, so you go ahead and repaint it that day, send the pictures, email the attorney, and then that attorney has that material to show that you made an alteration, and now you have to become compliant with every place. And if you had other things that were not compliant with the ADA, they can now file suit against those things. And it's likely that if they already saw the parking lot stuff, they already went around inside looking at like things in your bathroom and the spaces, in your aisles, just to make sure that they had other things to tag on, because they're not just trying to be friendly and help you most of the time. So you want to be wary about stuff like that. So don't jump to fix something without having everything checked. If you haven't had any complaints filed against you or lawsuits filed against you, we'll talk about that later. My supervisor will tell you that there's options out there for you to get a big check. So again, these are just more examples of reasonable accommodations that you can do. You always want to have it at least about like 3 feet wide so that your aisles are clear. A momentary blockage, like if you're restocking a shelf, like that's acceptable. But if you're leaving a box there and your employee is walking away and just leaving that barrier, that's not okay. We could go through other examples, like with counter heights and stuff. You always want to make sure that and I keep flipping back and forth. With the counter heights here, that's one thing. Also in the restroom, that's another area where people have like the biggest issues because, like I said earlier, with the sink levels, you have to get a special made sink height or cabinet in order to be compliant, but also like where the restroom toilet paper thing is hanging and the doors, if you have doors and they're swinging in, you're taking over the space that a person needs to turn around. That it's like these minor little things, you know, just having the hinge of the door open the other way can save you. And usually the mirrors in the restroom start about 40 inches high, and someone in a wheelchair would have to have a really high seat in order to be seen through that mirror. So that's like even one of those little things that can catch you on the non-compliance with the ADA. So the mirror height, the sink height, things like that. New construction requirements, the standards have changed. So you want to like follow the 2010 ADA standards. And again, you can look up those requirements because they get very specific. If a business undertakes any alteration, you know, like we said, we want to make it as accessible as possible. So you have to go with all the full height partitions, making everything compliant. Examples of alterations again is like moving walls, installing new sales counters, shelves, changing the doorway, the door itself, all of those changes. So you're making like a physical change, even repainting the floor, you're making an alteration. So you want to get in compliance. Getting in compliance again is beneficial to a business because your customer base will like you more, and you can actually have a bigger following of customers, you know, who are unable to access other businesses and stuff. And you want to keep people happy, and you can make yourself happy too with your tax benefits. Yeah.
If you make an alteration to your business that has nothing to do with ADA, you just made a change, does that automatically trigger the ADA part of it?
Yeah, because now I know that you have enough money and everything to make that change, so you should be compliant with the other changes. So it gets a little tricky, which though, I'm sorry, I'm taking a lot of time on this, so I'll just glance over this, but you'll see that when you talk to your landlord, you know, you might think, you know, I'm renting a space or whatever, but no, that landlord and you can both be sued. So you want to share responsibility as much as possible, but there are tax benefits for the business. And in the city of Fresno, if you have not been sued already, there's little grants that you might be able to apply, like about $10,000 or $15,000 to actually help you get into compliance before any trouble comes about. And if you need that information, send me an email. How businesses might face a claim. Again, an attorney can file a complaint against you or a lawsuit without even telling you that there's a complaint possibility through the ADA. And then there's different state claims that will allow them to take on other penalties. So it'll be like the UCRA allows plaintiffs to claim 3 times actual damages, no less than $4,000 per violation, and attorney fees and related costs of filing and such. And then the California Disabled Persons Act allows plaintiffs to claim 3 times actual damages, no less than $1,000 per violation. So you see, like, if they tag on this and this to the ADA claims, they're spending a lot of money. That's why I said usually it's about $15,000, and California is one of the most litigious states. So we see this going on all the time, and there's like rounds of when attorneys go about and start filing these claims for people. They could be the same plaintiff filing claims everywhere, and they don't actually have to visit your business. So you might not even be aware that somebody was even looking, because they might just be looking from a car to see, hey, look, I see violations out here. Again. I'm gonna start handing this over to Bill, because we have an addendum at the end that talks about CASP inspections that you can get done. And I don't know if there's yeah, because you get a certain amount of time to cure before you can tag on all of these penalties. So hopefully we're not at that stage yet, but
we'll give this turn. Yeah, so we actually went to a forum a couple weeks ago up in Richmond where just a number of businesses got together and sort of we'll let it all out there about the ADA, attorneys coming around and billing you and stuff like that. And it was a lot of people being very upset, a lot of money being paid out to attorneys and such, very, very upset kind of situation there. And so, unfortunately, we had an attorney there, but another attorney showed up who actually was suing businesses in the area, so it got into a shouting match, and it just got to be, you couldn't do anything. So now we're trying to arrange another forum up there, and in fact, we could work with the SBA to set that up down here as well. But here's the thing, the forum, when we bring it back together, we thought of titling it something like defending yourself in an ADA lawsuit or something like that. Well, the attorneys that we've been getting now to sign up for that said, no, that's not the way you should just say it. You should call it how to comply with the ADA, not how to defend yourself. It's if you think of it that way, it's sort of like what happened. How do you defend yourself from your roof falling in? Well, you fix your roof. That's what you do to defend that. And this is where the law has been helpful to you a little bit going forward. And this applies now to renters as well as landlords, as well as owners of property. Either can be sued under the ADA. But fortunately, there's these things called CASP. Yes, Certified Access Specialists, actually is what it refers to. Anyway, these are folks that come out and will inspect your property. They do cost something, unfortunately, but the amount of money they will cost versus a lawsuit is minuscule. So I did happen to just check up in Google here, and I found that there are several organizations like this in Fresno area that do referrals. They're trained to look for accessibility issues there. And here's the thing: once you do get your evaluation, then you've got several days, there are several periods of time, 15 days, to cure, at least on a technical violation, 120 days to fix, larger violations. You can actually extend that another 180 days if you're in the permitting process, if you need a little bit more time to do something. But what it means is that the statutory damages that you might be facing will be minimized in this situation. And here's the thing, I just want to skip ahead to, check police, landlord. This is all good stuff that we would recommend for you here. But there's a little bit more I wanted to cover in the commercial leasing area, which we put in this addendum here. Okay, so let me go here. I did identify a little bit about what CASP is about. And this was the aspect of how much extra time you get for if you've done a CASP inspection. But here's the thing, landlords commonly try and pass these responsibilities along to you as the tenant by saying, oh, the tenant will be responsible for complying with all laws of the state and federal and local government, or something like that. That means that they've now put the ADA compliance issue in your lap there. So what you want to do, a few things about this. First, there is a law that says that landlords are required to disclose whether there has been an ADA inspection on your property there, which is good, because then you know what things are out of compliance and need to be brought into compliance there. Okay, what we would recommend, if you have some leverage, actually back up for a second on leverage there. Teaching negotiation in law school and other things like this, what it all boils down to is what's your power? What is the power you have going into this negotiation? And if you have other options, you check out several different spaces where your business could be, you've got more power. You've got more power in the negotiation there. You can say to them, look, I'm not going to take this something on. I've got a couple other options. Landlords will be willing to negotiate if they see you have a promising business that looks like it can anchor their property over a period of time. But if there's been no inspection before you sign the lease, well, then you might want to propose a clause that says essentially, landlord will conduct the barrier removal if the premises are found to be out of compliance. And that would then limit you to anything that you yourself are doing that might be out of compliance, like that thing about blocking the aisles that inside the property where you're doing practices need to be fixed. That would be your responsibility. Now, there may be pre-move-in improvements that you've agreed to with the landlord, like putting up a ramp or putting aisles, further apart or something like that, or fixing the bathroom. There's usually some amounts of improvements at the beginning beginning of a commercial lease that the landlord is going to negotiate for you, this would be something to work into those improvements. Now, the main thing I would say is your leverage in doing this is always more before you sign. And another thing is you want to make sure when you sign that this stuff is in writing. You know, that there is a list of what the landlord will fix and what the tenant has to do. And that should be in writing as part of the thing you sign, because usually, just know this, any contract you sign usually has a little portion in it that says, this is the only agreement between us. All side agreements, oral agreements, not effective. Okay, so that's why you want to have this in writing before you do it. Now here's another thing that we recommend, and that is if there are large improvements to be made, you know, that ramp is going to cost something, or, you know, some other things that are going to be pretty expensive, you can always negotiate to try and amortize that over time. So let's say you're in the last 2 years of your lease, and it says in your lease that any major improvements will be amortized over time. Well, if then you find in that last 2 years on your lease, out of 5, let's say it was a 5-year lease, that you have to do some major repair there. Well, okay, if you have that language in your lease, then you're only going to be paying 2/5 of the cost of that thing. I mean, unless you renew your lease, of course. But the idea is to already have some language in there saying that you aren't going to be held responsible for this major improvement, even if you're only there for a short period of time. So those are just the main things we wanted to cover. Here's our information on how to get in touch with us. The website over there that I put up there, that's where you can sign up for those free office hours with an attorney. And those are confidential, of course, and we do that by phone or by web, or we also, when we come down here for Third Friday, we usually offer some office hours. In fact, you know, probably if anybody wants to talk after we're here, we can find a way to make that happen even today, even if there wasn't.
So before I pass the floor on to William, I just want to say I put on here www.fresno.gov/accessible Fresno. Is that right?
That's right.
Oh, that's what I wrote, but no, I'm not sure if that was it. Yes, Accessible Fresno. And right there you can apply for a free access inspection. Like we're talking about the CAS inspection. The grants that are available, that's up to $1,500 that you're getting if you're an approved small business that has not been, but like there's no lawsuit that's already been filed with you.
Yeah, that's right. They're often local grants that help you come into compliance. Did you say 50,000?
Well, this is 1,500. The grant could be up to like 10 or 15,000. Yeah. So now I know, like thinking about it from a different perspective might be easier. You know, like seeing it through different eyes. So I wanted to give the floor to William.
You know, you'll leave this on. That's
Good afternoon. I'm going to come to you guys from a customer perspective. Big key here is accessibility. Can I get into your business? Because if I can get into your business, it'll get around that you're ADA compliant. And the other things are accessibility within your business. You have doors that I can open and close. Is your restroom doors easy to open and close? Are your counters level? People not only with on crutches but in wheelchairs. Do you provide assistance to people who are visually impaired? You know, what do you have someone that can do a tour of the business or help with certain items? Those are the important things. If you provide assistance to me, to other people with disabilities, it'll get around, and that'll be good customer service. And the big thing you guys are going to deal with is customer service. That's the most important thing. The more you're customer service oriented to people with disabilities and people who are elderly, the better off you'll be. The problems I've had are basically doors. And the heavier the door, the harder to get in. So you got to make sure your doors that people can handle them, not only, and also people in wheelchairs can handle them too. That's important. And the restrooms are also very important too. You got to make sure your handicap accessible stalls are ADA compliant. I can use a regular stall if the handicap stall is occupied, but it's harder for me. Eventually, I end up in a wheelchair as I get older, so definitely the regular stalls are not going to be an option. So those are the things I have to deal with. Pretty much restroom accessibility, accessibility to the business, entering the business, and getting from the parking lot into the business. Because a lot of people, and I usually have a friend or family that I'm with so they can help me out. But a lot of people are independent. You know, they are just on a wheelchair or on crutches. And you got to make sure they can be accessible too. They might not have a family member or a friend with them. But the whole thing with being ADA compliant to assist people who are disabled and elderly is customer service. You got to make sure the customer can get into your store. You got to make sure the customer is comfortable in your business. You got to make sure that the customer can use your restroom while they're in your business, doing business with you. And because all of that, if you don't do that, you say, I'm not going to have anyone with disabilities or who are elderly in my business. If word gets around that you're not going to do it, lawsuits are one thing, but also the other damaging thing, word of mouth. So you got to make sure you don't, those are the big two that ruin the business. One is lawsuit, the other one is word of mouth. Now with social media being so prevalent, you can get blasted all over the place. And maybe if you don't want to deal with that, you become ADA compliant. You work, if you can talk to someone who's disabled, say, okay, I'm starting a business or I'm in business. What do I do to make it ADA compliant? And hopefully you have a friend or even elderly. You don't have to be disabled. Someone who's elderly, you can talk to them and say, how can I make sure you can come into my business and do business with me? Or how can I make sure there's, that if I can do that, that you can pass along my business to other people who are elderly, who are disabled, because you're dealing with two big demographics. And even though we're in the 21st century, a lot of things are still backwards from my experience, because I don't think we're all, everybody says, people are more aware, yes, but I think people don't know how to be ADA compliant. So I think we need to get everybody into the 21st century, get the businesses ADA compliant. And the more you do that, the more you make things accessible for us, the better your word of mouth is going to be in your business. And that's the most important thing. You want to be successful in your business. You want to make a profit. You want people to say good things about your business. That's the way you do it. Hopefully you can talk to someone that that can share with you, like I just shared with you some of my experiences, I'm going into this, you know, just try to be accommodating. Talk to people who, I would go to people who deal with disabilities and talk to some of the clients there and say, ask them, you know, how can I be more accessible to you in my business? And maybe that's a route you guys can do. Thank you.
Thank you.
Thank you.
I just wanted to add one more thing off of that, William. Like he said, it's the ADA requirements, like they could be specific and everything, but they're still just the minimum. So you could always, you know, go above and beyond that. But also, if you do see something that you can easily change, don't get afraid of when I said that, hey, you make one change, you have to change everything, because it again goes to reasonable accommodations that you can change and what is not doing an unjust like change to your bottom line as well. You know, like we said that there could be something on there too. So if you have something where you have exposed pipes in the bottom of your sink or something, you know, you're like, eek, I'm not gonna change that because I don't wanna go to the 2010 standards. Like, you can still get in trouble from that because it's so minimal and you could easily change that. Also, like the height or like actual bars, there should be around the restrooms to help people if they're, you know, lifting themselves up or something, you know. There's even an 1.5 inch clearance or something that gets very specific. But, you know, those are the easy things to just look up and put into place, you know. It's not a big cost deterrent. So I encourage you to look into those as well.
And CASP would be a group to bring in to look at that and say, hey, you know, can I change this without bringing, you know. Did you say there's a free accessible inspection?
Yeah, so there's the CASP inspection is usually $1,500, and small businesses in Fresno can go to fresno.gov/accessiblepresno and fill out the form right there to apply to get that inspection. Now, once you get that inspection, you can actually get a certification in some of such, I forget exactly, it's in the presentation. And then you can like list that in front of your business to show that you're trying to be compliant, and it also stops any like, you know, bad plaintiffs that are going around just trying to sue people from tying you into court with that.
Yeah, questions?
Yes, I have a question for William, and it relates to, for example, the Netflix lawsuit, because even though they don't have a place of business, they don't have any brick and mortar stores, they have a service, they have a business, what they provide for their media, you know, and entertainment, and that not being accessible. So I wanted to know in terms of maybe packaging of products, you know what I'm saying? When you talk about accessing a business, and let's say there's a business that is, you know, providing some type of food that's packaged, do you ever think in those terms or say, you know, this is poorly designed? You know, I wonder if this packaging could be, you know, more accessible, or just kind of thinking a little bit differently, because obviously Netflix probably didn't expect to get hit with that lawsuit. But yeah, it's something to think about, these different alt tags, you know, a website. So what about packaging? You know, because that's a business. Somebody's distributing something to you for your enjoyment to eat, and you have issues with the packaging. You know, what thoughts do you have on that?
I would call the place of business, right, and say, hey, I'm having problems with package X. I had to get a friend of mine to unwrap it, or, you know, I just threw the thing away because I couldn't do it. Again, communication is the most important thing. You know, I on my end have to be sensitive. The thing I don't want to do is start yelling at you guys, right? Like, oh, I couldn't open this package. It took me forever. It took me an hour. No, the thing I always say is yelling will not solve anything. All right? So if I just talk to you calmly and say, hey, I had a problem with your package, you may need to talk to your R&D people and get it fixed. I may not be the only one that's having this issue with this package. Someone else may be. You know, so, you know, got to be some open dialogue between both the client and the company to get it resolved, you know, instead of yelling and screaming during the lawsuits. I didn't know anything about the Netflix packaging machine. Special. I mean, but yeah, there are some stuff that, as long as you keep communication open, I think you're okay. Yeah.
Thank you.
Other questions? Again? Yeah.
Good presentation. I like a lot of good information. Got a couple of things. One, I know protocol kind of dictates that if you're going to have a meeting at lunchtime, you provide a lunch, so you know future references. My message is to Victor, because I know he knows better. You guys come down here on a regular. I'm from Bakersfield.
Oh, nice to meet you.
I'm in the process of working with a small group. We are opening an entrepreneurial super center. There's a super hub that's in buzz now, and we're opening one. I wanted to find out the possibility of getting you to come down to Bakersfield as one of your stops in this service.
Love to talk with you about that, and at the very least, we can think in terms of starting already office hours or links with this training that we have right now over the web. But yeah, let's talk some more about some live visits. Great. We also have, as I understand it, there's a new sister clinic that is starting at UCLA, which might be a little closer to you folks.
No, not really. We end up getting sent to LA for a lot of services. LA is not closer, plus there's grapevine, so that is why I should.
No, I was just thinking if they were, they might think of meeting us in the middle kind of thing. Us coming from Berkeley and them coming up. But let's talk a little bit. Let me get your card and we'll talk about it for sure.
Appreciate it.
Other questions people might have? Okay, well, great. Well, we're going to hang around afterward. Kevin and I, we're going to have some office hours where we can talk with people. Let me make sure we get your card and you get my card. And let's talk about Bakersfield. That would be great. And thank you.
You're welcome.
Appreciate it. Yeah. All right, everybody. Thank you.